Welcome to this training session brought to you by the Society of American Archivists, Archivists of Religious Collections section. My name is Nan Cano, and I give this acknowledgement that I live and work on the territory Anishinaabe, Haudenosaunee, Atawandaron, and the Wendat peoples, and pay my respects to elders past and present. Today's topic is United States copyright. Before I introduce our two presenters, let's review the notes on this disclaimer slide. The content in these presentations is for information only and is not legal advice. Our views do not represent the organizations where we work. We do not make any endorsements or guarantees. We are not liable for any loss or damage caused by your use of the content we provide. It is your responsibility to critically evaluate the content provided in the presentation or any accompanying materials. And please remember the points on this slide as well as we go on. You will not be able to use your microphone or video during this session. You can click on the closed captioning button at the bottom of your screen, and under live transcript, click Enable Auto Transcription to get closed captioning. There will be a question period after the presentation concludes. You should only use the Q&A feature to ask your questions. We will not answer questions in the chat or unmute attendees due to time constraints. Please be respectful in your interactions. We expect you to follow the SAA Code of Conduct. This session will be recorded. There's a short survey after the session ends. And we encourage you to join the Society of American Archivists if you're not a member. And we really thank the Congregation of the Sisters of St. Joseph in Canada for hosting this webinar. And now I would like to introduce our presenters. Russell Gasero was the archivist for the Reformed Church in America from 1978 until his retirement in 2020. Prior to that, he had worked in the archives of the United Nations for 5 years. Russell has an undergraduate degree in philosophy from Hope College and a graduate degree in educational philosophy and history from Rutgers University. He is a member of the organizing class in the Academy of Certified Archivists. Russell helped establish the Archivists of Religious Institutions, was the co-founder of the Lone Arrangers, one more time, the Lone Arrangers Roundtable, and was a former moderator of the Archivists of Religious Collections. He's been a regular presenter on religious archives issue at the SAA and regional gatherings. In his retirement, he established Wit Intellect Publishing LLC and wrote his reflections in A Historical Footprint, Reflections on a Life in the Archives. When not reflecting on archival topics, he enjoys sci-fi and fantasy films and sitting back and just being mellow. Our other presenter today is Scott Kiefer. Scott has been the provincial archivist for the Daughters of Charity, province of St. Louis and Emmitsburg, Maryland, since 2018. Prior to that, he held positions with the government of Fairfax County, Virginia, Brooklyn College, the American Academy of Rome office in New York, and the American Museum of Natural History. Thank you all for coming.
Okay, well, welcome. I wanted to start by saying that I think there are 3 essentials for archives in regard to copyright law and copyright issues. First is to be clear about ownership, and I mean ownership of the copyright. Second is to understand transfer of copyright, and the third is to understand assignment. You need to know how that may happen upon the acquisition of a collection. And we're going to discuss that throughout this webinar. Now, understand fair use and risk as well. Before we start, let's start with a disclaimer. Neither presenter is an attorney, and nothing in this presentation should be construed as legal advice. This presentation is for informational purposes only, and it is the responsibility of all viewers to assess the information herein for its value to their organizations and situation. And I do hope there will be some good value for you. I want to begin with a little background. So what is copyright and why is it important? Now, copyright is a part of intellectual property law, and its primary goal is to promote creativity. And it does that by protecting the individual rights that a creator, that is, the emphasis on a creator, has upon creating any work. And those works are vast. It's books, it's musical compositions, it's photos, it's drawings, sculptures, even semiconductor chips. There's so much more. When something is created, it is automatically protected by copyright. From the moment of creation, copyright law assures that there's financial gain with creation, that the owner does indeed own it. Without that kind of protection, I think we could well wonder if any creative person would create content. If you wrote a book and anyone could copy it, anyone could sell it, would you put in the time required to create that work? So copyright from the creator's perspective is very important. The intent is to promote creativity by protecting it. And that carries through to collections and archives, because the copyright continues to ensure that the creator has control over their creation. And some violations of that are very minute. We don't realize it, but they're violations nonetheless. Think about how many books you've read where a character recites lines from a popular song. Without express consent from the song's creator, that becomes illegal and technically is a violation of copyright as the song quote increases. There's no ill intent on doing that. The author likely did not ask for permission, didn't think of it, didn't pay a royalty to the songwriter. But those are the issues that come in copyright. So copyright law is granted by Congress, and the first Copyright Act was begun in the very beginning of the United States in 1790. And there are distinctions that evolved over the years with copyright. The law changes and it's adapted to do all kinds of new situations and new technologies. In the 1909 Copyright Act, that's one example, works had to contain the proper notice in order to be protected by federal copyright law. With few exceptions, any omission, misplacement, anything that missed putting that notice in the work would mean that it might not be protected under copyright law. Publishers had to be sure they were doing it right. This was a publishing problem. They were printing it correctly so that they could preserve the copyright protection and make sure it was not an unauthorized copy. And that remained a requirement until March of 1989, when the US became a party to the Berne Convention of 1886. The change then was that the copyright notice is not a legal requirement for protection. Notice is optional for works that are published after that date. So protections under copyright begin with the creation of a work, not a registration, nor the publication of a notice. One popular belief that I've heard many times, and it's been repeated, is the poor man's copyright, where you send a copy to yourself by registered mail so that the date is postmarked to prove that it was created. I don't believe it's ever been used in any copyright litigation. But copyright is protected upon the creation. There have been a number of cases in the last couple of decades that are popularized that talk about copyright. One is the Authors Guild versus Google. That was about a fair use concern in copyright law and the transformation of printed copyrighted books into an online searchable database. You may be familiar with that if you've ever looked for Google Books. They were scanning and they were digitizing books, and the case centered around the legality of that. So in 2005, they brought lawsuits by the Authors Guild on behalf of 3 authors and by the American Association of Publishers. It was an infringement case. that maintained that Google had not sought the author's or publisher's permission to make scans of the books still under copyright, and then offered those books to readers. Google tried several variant options. They tried to settle the dispute in a number of different ways, and they all ultimately failed. And in late 2013, after the class action status was challenged, the district court granted a summary judgment in favor of Google, dismissed the lawsuit, and affirmed that the Google Books project met all the legal requirements for fair use. So that was an important case. They tried to bring it up to the Supreme Court, and they denied hearing the case. So that was pretty much the end of it. And it was likened to the public libraries and their ability to lend books to readers free of charge. So it's a fair use issue. There are other cases too. These can be seen as a triumph if you're coming from the non-creative standpoint, or they can be a crushing defeat if you're the creator. Depends which side you're on, but it did set a standard for helping to understand fair use. A related case was a few years later, in March 2020, as a result of the shutdowns caused by the COVID-19 pandemic. The Internet Archive created the National Emergency Library. You may remember that. And that removed the wait lists that were used in Open Library and expanded access to those books for all readers. The National Emergency Library was met with a lawsuit from 4 book publishers, and the library was shut down in June 2020. There's not a final judgment yet on that case, but those are the types of cases that normally come up under copyright law. Rarely does it involve an archive. So just to review quickly, copyright is considered the exclusive legal right protecting intellectual creations from unauthorized use. That's what you need to know. Some variant of this law has been in use since the 15th century after the invention of the printing press. And it continued to develop right up until, in the US, the 1976 Copyright Act, when a stringent guideline of what falls under copyright protection was established. And it was further amended in 1998 after it became evident the internet and digital rights were about to become major factors in modern life and affect copyright issues. So again, copyright ownership, it's really important to know, can only be transferred in writing. It can only be assigned to someone else, to a publisher or another individual or an institution. It doesn't transfer with ownership. In such an agreement, either the entirety of the copyright or certain prescribed rights and usages are assigned to a different owner. The other way to allow for permissible use is by licensing the creation. And that's more in the area of creator rights than it is archival rights, so I'm not going to talk any more about that. But the bottom line is that an assignment conveys ownership of the intellectual property, and a license conveys only the right to use the intellectual property on stated terms and conditions. Ownership of a document holding a song does not convey copyright. Only assignment transfers more legal rights. So all works are protected upon creation. Want to emphasize that again. There's no need to register a work. Registration does make an infringement case easier, but that's again on the side of the creator. Doesn't really apply much to archives. There are opportunities for redress that are not available if you don't register the work, but that's again more for creators. Registration helps and allows for those additional benefits should that copyright be violated. Now, infringement, if you get sued for infringement, it's any quote, crop, derivative, distribution, or translation of a work that was not formally licensed or transferred. So when any of the rights of the copyright holder are violated, an infringement occurs. This means that any quote, any crop, any derivative, all of those things, that work was not formally licensed, it wasn't assigned, and that could be considered an infringement. As I indicated earlier with a song, but something as simple as a quote from a poem or a song that was at the heart of a work might be an infringement. That's why major publishers have large rights departments in which you request rights and you pay for those rights. Also means that a full-length, illegally obtained copy of a book, a pirated copy, you see those warnings on motion pictures now, a photo, a film, all of those are infringements. Reuse of a work without permission is sometimes allowed under the concept of fair use. And Scott's going to talk more about that later. Big change was with the Digital Millennium Copyright Act. In 1998, that was passed by Congress, and that amended the copyright law. It made some significant changes that moved copyright from being a civil case to a criminal case in a number of instances. It allowed for damages that went beyond just what would have been the damages had the original creator sold that work. It seriously did change things. A lot of it was motivated by the entertainment industry. And you may remember, if you're old enough like me, some of the lawsuits that went on at that time. It was pretty significant. People were having problems downloading music and being sued. One could say it was motivated more by greed, but it wasn't from individual authors as much as it was from an industry. What it did, there were three main things, though, that came out under the Digital Millennium Copyright. It established some protections for online service providers in certain situations if their users engaged in copyright infringement, protected them, not so much the user. And it had the notice and takedown system that still exists. That came out of the Digital Millennium Act. And that allows the copyright owner to inform someone about infringing material so that it can be taken down. Again, an online orientation. It encouraged copyright owners to give greater access to their works in digital formats by providing them with legal protections against unauthorized access to their works, like hacking passwords or circumventing encryption, etc. And it made it unlawful to provide false copyright management information. So you couldn't name authors and copyright owners that didn't exist or titles of works. So that was a major change that came with that. Good copyright information sources is seen here at guides.library.cornell, where there's a very useful chart that shows you what the copyright terms are. One of the biggest unpublished works, life of the author plus 70 years. So that would be works from authors who died before 1953. That's significant because if you have an author who is 100 years old in 1953, he goes back to 1853. The work he did in 1880 is not yet in public domain. It's just coming in. That will be in January 1st, 2023. 2024, that will be died 1 year earlier, or later rather. The unpublished anonymous and pseudonymous works, there's a very great chart. I encourage you to look at that when you have questions about copyright. It summarizes it very, very well. If you want the actual copyright law, you can find the copyright law here, all 400 plus pages. I think it's 480 pages. And it's a PDF file with 15 chapters and 20 appendices. That's where you'll find all the answers. And you'll see all of the latest revisions that have happened to copyright law. There's a couple of pages of recent revisions. So it's a law that is constantly changing and emerging, and we'll see what the future brings. Those of you who remember Sonny Bono know that when he was in Congress, he was trying to change the copyright law so that it would be in perpetuity. Nothing would ever go into the public domain unless somebody placed it there themselves and assigned those rights over. So there's all of these changes that happen.
I'd like to go and talk a little bit about religious archives and why they are different. This is a webinar brought on by the ARCS section after all. Russell, can you go back 2 slides, please? You brought up an interesting point here that I'd like to go and show an important distinction here. No?
No, I got to go in the other direction.
Okay.
Yep.
That's fine. The fact that religious archives often contain a mix of, number 6, please, contain a mix of materials given to the archives by an individual and those given by a corporate body or an institutional body is a common trend among many archives, and particularly religious archives. If you have the works of a sister or a brother or a priest or a rabbi, and they donated their works, those are donated on an individual level. If you have something created by a parish or a diocese or an archdiocese, those are works that were created at a corporate level. Those have different copyright terms on them, whether they are published or unpublished. Different denominations have different levels of centralization. For example, a Catholic diocese is a corporation sole. Anything put out under the diocese name, the copyright remains owned by the diocese as a nonprofit organization. That's not true in all denominations. Other denominations are far less centralized than the Catholic Church, and even that's pretty decentralized when you get into corporate law. But denominations that are far more decentralized can have materials where the copyright is owned by an individual parish. Sometimes those parishes still exist, sometimes they don't. Sometimes everything reverts back to the diocese. Some things are just owned by individuals. There's a lot of different layers and levels to determining who owns what copyright and whether it falls under an individual time period or a corporate time period. It takes a long time for materials in the corporate time period to enter the public domain. If there are corporate files that are not your own, as in, let's say, for example, you're a denominational archive and there are materials from different parishes, materials created by the big overarching denominational organization, you might have the full copyright to those, or at least your institution does. If you have those materials from an individual parish, there's a good chance you don't. And if you want to go and do something with those to make them more public or to digitize them and put them online, you're going to have to probably get some approvals from somewhere. Next slide, Russell. I would like to talk about how copyright can be a very much a hurdle to digitization and sometimes the way out of that. You as the archive, as a representative of your organization, assuming that you have all of your higher ups approval, you have the right to digitize and publish any materials that you own copyright to, whether they are virtue of creation or whether they are virtue of donation. So if somebody donated the paperwork, somebody donated a set of papers and they signed the copyright over to you, by all means, you are free to do what you wish. If your organization created the papers, by all means, you are free to do as you wish. It does not necessarily mean you should do so ethically. Your denomination might not allow it, but in terms of US copyright law, you have the right to publish those materials and digitize them. Along with that, anyone has the right to digitize and publish materials in your possession that are in the public domain. That copyright is not owned by anybody. Nobody can stop you. You may publish materials you do not own copyright to if you have the permission of the copyright holder. But for considerations beyond these areas, you might need to go and think about fair use and library use, which are sections 107 and 108 of copyright law. Next slide, please, Russell. Fair use is a defense to copyright infringement. So if you get sued for copyright infringement, you can go and claim fair use under a very specific set of circumstances. You can say that you were using your materials for criticism or comment or teaching purposes. A teacher can go and advertise that they will show a film in class and then show it in that class, and that is considered fair use. You can go and do criticism or comment or satire on a work and use a small portion of that work. If you get sued and you fall under any of those categories, that can be your claim. I highly recommend you consult with a lawyer if you're in that scenario before you make that claim on your own, but that can be your claim. It fundamentally takes into account the ability of a creator to profit from the work. As in, the goal of copyright is to protect the creator and make sure that the creator can monetize their work. Anything that you do cannot be preventing that. So it really considers whether the use is commercial or educational or nonprofit. the effect of the use upon the potential market is the other big consideration. If you're going to digitize a book that got published last year and try and put it up online on your own, you will get sued, and you're not going to get out of that one. If you make a page, if you copy a page for a researcher, a little bit different. But if you go and make a whole book available, and a recent one at that, you will get sued and you will probably lose. As a few other examples, COVID saw a fair amount of use, as Russell brought up, of teaching scenarios that were all virtual, and books and research materials being made available in some different ways. That was a fundamental claim of fair use under right to education. Sometimes it works, sometimes it didn't. As another example, if there's a defunct local organization's newsletters, and that organization had no successors, even if you don't necessarily own the copyright, I will remind you that those under copyright for 120 years, you might be able to make a fair use case for digitization and making them available. They are not interfering with any market. You cannot track down a copyright holder. You might be able to make a fair use claim on those. A lot of it really depends on how comfortable you, your organization, and your council are with accepting that risk, particularly if they are valuable research materials for scholarship. And again, do not interfere with any potential market or monetization. You might be able to make a claim out of that. Really, it is a situation where you should consult with a company attorney to assess the risk if this is a plan of yours. Library use is a claim for organizations that are open to the public for library or archive research. So if you're completely closed, you cannot make a claim for library use at all. But library use allows for digitization for the purpose of preservation. Say, for example, if you take high resolution photos of a scrapbook that is falling apart, that is considered digitization for preservation. If you go and digitize a cassette tape or in reel-to-reel audio, that could be a claim for digitization for the purpose of preservation. But again, you must be open to the public. Once you put it online, you are becoming a publisher, and you're accepting all the risk of becoming a publisher. And I also deeply, deeply recommend having a takedown system or mechanism as a risk mitigator. Have that notice that says, if you own the copyright to this or claim you have the copyright to this, contact us and we will take this down until we figure this out. That is a big, big risk mitigation factor. Next slide, please, Russell. Photographs. Photographs are another interesting little format. Photographs have all the rules of copyright that written works do. The copyright is owned by the photographer or the creator. However, in photographs, there are often people in the photos, and those individuals have, quote, reasonable expectation of privacy. That is the standard by which a person could have interest in a photograph. The reasonable expectation of privacy, if you're out at a concert, a public concert, and your photo gets taken, you do not have a reasonable expectation of privacy out in a public venue like that. In your home, in your workplace, that you might have a reasonable expectation of privacy. In fact, you probably do. You definitely do. But if you're out in public, you do not have that reasonable expectation of privacy. Again, there are ethical considerations, but those are not the same as legal considerations. If your image, if your photo, even if you're in that public park, and you've not signed or accepted any statement of use of your image, if your image is used for commercial purposes, one that implies advocacy or of endorsement against your permission, you absolutely have the right to sue for that. And if you are on the library archive side who posts that photo, you have the strong potential of getting sued, unless you get permission. Implication or advocacy of endorsement, those are really the standards of private image for photographs that are still under copyright. Hidden faces, perfectly fine. Back of the head, perfectly fine. If you can tell who it is, there could be a problem. Sound and film. Film, as in pictures, functions under the same copyright laws as written or photographic works. There are the considerations of anything included in the film that might have copyright or trademark to it. So if there's a song in the film, or if there's a trademark character, if Mickey Mouse makes an appearance, that could cause you some problems in terms of copyright. But moving pictures really follows the same rules as written or photographic works. And I remind you, again, consider the difference between published and unpublished. That sort of casts a pall over all of these. Sound is its own monster and behemoth. Prior to 2018, virtually all sound recordings were under copyright, regardless of age, regardless of whether they were published or not. A professional sound recording has many different layers of copyright to it. It has rights associated with the songwriter, with the performer, writers, producers. Everybody has their own copyright to it. As an example of that, the works of Beethoven are in the public domain. I can go and find a Beethoven score pretty much anywhere on the internet. That's public domain. Nobody can stop me. Nobody can stop anybody from putting it out there. But if the London Philharmonic records a Beethoven symphony, the London Philharmonic now owns the copyright to that performance because the performer has a copyright different from the writer. Prior to 2018, all sound was governed by state law, and every state had different laws. The Music Modernization Act is really what began to let published sound recordings pass into the public domain, a lot closer to film or written works. But unpublished audio recordings are still very often indeterminate and very often governed exclusively by state law. Effectively, if you are dealing with unpublished sound recording and want to make it available in some published format, you better call a lawyer because there are sound recording is a complete nightmare. There are Stevie Wonder tapes where nobody has any idea who owns the sound recordings, not the released albums, but the unreleased stuff. And people genuinely have no idea who owns the copyright on them. Next slide, Russell. Orphan works are those with unidentifiable copyright owners. This is due to not quite knowing what the work is, due to confusion of who is the heir, corporate succession, digital works, unknown, unpublishable materials, unpublished materials, things that the stuff that we come in contact with in archives so frequently. Right now, the absolute time limit is 1903. If it was created before that and definitively created before that, it's considered public domain. If it was created 1903 or afterward, then there could be some problems. It's highly recommended that you do your due diligence to try and track down a copyright owner. But as we all know, that's often very difficult and frankly impossible. It makes for the strange scenario where it's both undigitizable, unpublishable, undistributable in online methods. And yet if you can't find a corporate heir or a copyright heir, it's a good chance that nobody else can either. And so it really does come down to what balance you and your organization and your council are willing to strike between risk and making the materials available. The chance of being sued in many of these cases is extraordinarily low, but it does exist. And that's why we recommend things like talking to your counsel, having takedown notices, and really considering what effects this copyright has upon the owner or potential owner, and how that changes when you really can't even find an owner. Next slide, Russell.
Hey, I had mentioned that copyright will not be transferred with ownership. It has to be assigned or licensed. So when you're transferring records to the archives that come from individuals, you want to try and include the copyright permissions with that transfer, that they will assign all rights to the archive so that you can use the material. That may or may not cover everything in a collection. You could have photographs in there that weren't taken by the creator of the collection, which the copyright belongs to somebody else. You could have newspaper clippings which do not belong to the owner and then they belong to the newspaper. And that's a recent issue I had as a publisher now, in which I'm including in a book for a person a photograph that came out of an old newspaper, and we were trying to do our due diligence and track down where is the creator of the photograph. The newspaper no longer exists. It becomes very complex, and all you can do is demonstrate that you've done due diligence to protect yourself. But for archives, the essential part is that copyright ownership must be transferred in writing. I can't say that enough. I've heard so many people say, well, we own it, so we have the copyright, and no, you don't. We want to be clear on that. And I think it's also an issue when you have users that come into you to make it clear to them that you do not own the copyright for the collection they're using. But I've always thought that that's their problem, not my problem. Not to be callous about that, but I can't track down ownership and do due diligence for them. That becomes their obligation. And again, it's a risk management thing. Is somebody going to really sue you because you used an excerpt from a letter from somebody who was writing in 1920? I think it's minimal. You have a minimal risk there, and it becomes a risk management issue. We pass on to public domain. That means that it's not protected by copyright. And the other thing that's in public domain, ideas, facts, and information. Because people, I've heard people joke about, can I copyright that word? No, you can't copyright a word. And then people think that they could somehow control speech if they could copyright these things. Public domain changes every January. Now it's about 1926. And again, on the chart I mentioned at Cornell, you will see that. That's very clear on the chart. But you also have to be aware of things in public domain, and you got to include derivative rights. And those are translations, musical arrangements, dramatizations. As Scott mentioned about the symphony orchestra, their performance is not in public domain, whereas the original music is. And you have to be aware of those things. He mentioned also a scrapbook. Those can have multiple issues because depending on what they put in the scrapbook, while they say you can own copyright to my scrapbook, you don't own copyright to the contents of the scrapbook necessarily. If they were family pictures, well, they'll transfer that to you. But if they're putting in other people's pictures, again, you don't own the copyright to that because that hasn't been transferred, and the person giving you the scrapbook doesn't have any right to transfer that copyright. So it becomes very complex. For the archives, it's only if you're going to begin to publish this. And that means putting it online. If you're doing a website exhibit, you're technically publishing it. So you have to be careful. The takedown would be simple. You just take it down, not a problem. For me, when I publish a book, well, it means I'm gonna have to recall all those books. And I just took a big hit financially. We don't want to do that. So you want to be very careful about those things and where the derivative rights are in any kind of copyright and what is public domain and what is not. You get into other kinds of intellectual property, and that's trademarks. That's different than copyright. That's more about branding than it is about content. And that's where you do protect words and symbols because those words and symbols indicate the source of goods and services. And here you can think of things like Harry Potter and Disney creations. Disney was very, very strong about going after anybody who misused any of their images, and they would order that to be taken down. Others are not so. And for them, again, it's, well, are you helping us or hindering us? Those are issues, but we don't really deal with trademark issues as much in the archives. Finally, there's the CASE Act. That was in 2020, and that created a copyright claims board within the Copyright Office. And that's a new way to handle cases of infringement for those people. It helps those who can't afford protracted litigation. You can still have access to redress, and you can have this claims board settle that court. And that comes under Section 512 of the Digital Millennium Copyright Act. And so it's those who can't afford expensive litigation. What in the past was something that would hinder somebody suing you for copyright infringement was the expense. Again, the Digital Millennium Copyright Act changed that because they don't have to necessarily bear the expense anymore. And so copyright, you think of the hours that it's going to take a lawyer and going to court and hearing the case, it can be very expensive in a short time. So someone would sue in the past and they'd say, well, you know, it's not worth $10,000 of my time to sue for something I maybe could have made $2,000 on. That's changed. So it's a new kind of world. And that's we have to deal with it. So I want to also point out there's a Copyright Alliance that you can get a lot of helpful stuff. They're copyrightalliance.org, and they have a lot of resources on their website, as well as the government website. Those are places where you can find a lot of answers, a lot of useful resources.
And I will add one thing to your list of public domain materials, Russell, are government, at least in the United States, are government publications. If it's a government document, then it falls under fair use. Anybody can use any document created by the United States government or done for hire by the US government. So that includes if the government hired a photographer to take a bunch of photos at Yellowstone Park, that is considered government property and goes to the National Archives and is perfectly fine to use in any publication at all whatsoever. Just one other little public domain thing. But the big takeaways that we really want you to come away from this is copyright is complicated. You probably knew that already. That's probably why you're here. If you need a really solid copyright decision, we highly recommend you talk to a lawyer or your institution's counsel. You can read the 500-page copyright law yourself if you'd like, but I really don't want to, and I highly doubt you do either. In the archives world, you do not necessarily have to be afraid as you think you do if you do your due diligence. Researchers are generally responsible for their own copyright research in whatever project they're working on. When I can give advice, I do so. If I know that materials are owned, the copyright is owned by the archive, I'm happy to set them up with our individual who does that, who handles that sort of thing. But largely, that type of work is the researcher's problem to deal with. When it comes to digitization and publications, then you might have to think a little bit more. But as long as you are doing your due diligence and discussing things with your counsel, there is not as much risk as you think. There's a lot more leeway in terms of fair use than you might expect. And you do not, the chances of being sued into oblivion are not that high as long as you are smart with what you're placing online. Ultimately, you, your institution, and your counsel have to assess your own level of comfort with risk. But I'm very glad you are all here because every single person in the archival profession should have some familiarity with copyright and how it functions. It's a big deal. It affects a lot of our work and it affects a lot of what we're doing more and more as the digital reach grows and grows. But that being said, that is the end of our formal portion.
Okay.
Russell, anything else to add?
I'm gonna just one other thing, another issue I hadn't mentioned, and that's works for hire, because that comes up a lot in the institutional setting. That only applies to someone who actually creates that work as part of their job. So where Scott was talking about the public domain and the government, if you have a photographer whose job is to go out and photograph landscapes, let's say, that's a work for hire by your institution. It can be very tricky as to what the requirements are, but if it's created by the institution, then the institution would own the copyright on that and not necessarily the individual. But if they hire a photographer to do a job for them, that's not a work for hire. The photographer is doing the work, but they don't own the copyright. It's a tricky one, and that yet throws one more monkey wrench into the situation when you receive a collection as to where did it come from.
I have a few questions, gentlemen. Are we ready?
Let's go.
All right. I think you did cover a few of these, but I want to make sure that the queries are covered. One person has an affiliated group of churches, not a denominational structure, but they had various publications, and those publishers are now defunct, gone. I think you touched on that earlier. How does copyright apply to these situations when they could not, there is no extant publication to seek permission?
I think that would depend on the nature of how each of those individual organizations went defunct. If they corporeal, corporeal, financial, and spiritual assets went to another organization, a successor organization, and that successor organization would then own the copyright on those materials. If there's no successor whatsoever, they would probably be considered orphan works.
Yeah. Okay,
The organization itself doesn't exist anymore.
that's right.
Nobody can claim it. Nobody can sue you for it. I mean, they are gone.
Okay.
Russell,
We have
and that's the other thing. There can be a lot of discussion. Russell, do you agree with me on that?
Oh yeah, completely. It really depends on what happened to that court. Did they merge? That's a different story. But they just simply disappeared. They don't exist. They're not a legal entity anymore. Yeah.
Okay, we have a few more questions. I'm doing my best to cover them before we say goodbye. Someone is inquiring, are there legal consultants with copyright expertise who could be paid to survey an archive's public-facing digital access? Yes, there are attorneys, right?
Almost, I mean, certainly.
Yeah.
I've never heard of an archival organization paying someone to do that, but I'm sure a lawyer would happily do so if you paid them.
Yeah, sure. Yeah, make sure you get an intellectual property lawyer, though. Don't just
That's
go to
right.
any lawyer. It is a specialized field, and not all attorneys know it well.
We use that in our own archival decisions, and it served us well. What if you have a copy of a book, but it seems to be a rare book, one of the only copies in existence? What if it were subpoenaed in a court case? Could you scan the book to answer the subpoena to avoid risking the physical copy?
That would probably be considered within, as long as that copy is only going to the lawyers involved in the case, that would probably be considered copying under fair or library use.
Yeah.
Yeah, I would agree. I agree. That's what you point the finger and say, they made me do it. But I think, yeah, that would be fair use. And if the court would accept it, I would want to check first before you did all the work that the court would accept the electronic version.
I have a question from a religious point of view. Let's say there's a collection of correspondence between the hierarchy, the Chancery Office, and the current lead officer there, bishop, to the leadership of an individual religious community. So the bishop's writing to Reverend Mother.
Mm-hmm.
And it's how long and what are the safeguards to take with that kind of correspondence? Things that might have been controversial 50 years ago no longer are, but does the archdiocese own the letter that the bishop wrote? And so that the community then owns the physical piece of paper but cannot digitize it?
So I'm going to, Russell, go ahead.
Yeah. I was just going to say there's other issues that they're raising here which relate more to confidentiality and privacy, which is a whole different thing than copyright. The copyright, again, it depends on who the creator is. The copyright is owned by the creator. And if it's a work for hire, which is what an administrative person would be, then the institution would own the copyright on that. But that's different than the when you talk about things that were sensitive, now you're dealing with privacy and confidentiality issues, which are different.
Yes.
Yeah, ethics and copyright are not the same thing. When we're talking about copyright, we're talking about United States copyright law. If this letter is Catholic, even if the Copyright Office can't do anything to you, the canonical structure, Church in Rome, might be able to. Those are completely different things.
All right.
Or not. What do I know?
It's all scary. So in another field, another question concerning a record album. He wants to digitize a record album to distribute to friends for free. The songs are covers. Most of the performers are deceased. The recording company no longer exists. Do they need to track down heirs to the performers or anyone with the original company to gain permission? a little complicated.
I would say the performers, even if they're deceased, the copyright transfers automatically to their heirs. So it depends on how long they've been deceased. Again, that rule is 70 years after death. You'd want to sort that one out very carefully. And again, what is the risk to you? In the past, again, the difference between it being a civil act and a criminal act is in the past, the copyright owner would have to prove damages and how much the damages were, and you would be liable to that amount of damages. Under the present law, they don't have that. That's why you see the warnings on DVDs and such. It's a criminal act. You can go to jail for this many years, fines of up to this much money. You can get paid not only your loss, but also damages and other kinds of things.
Okay, we only have a few minutes left.
Can I jump in on that one?
I'm sorry,
real
Scott.
quick?
Yes.
Um,
Excuse me.
I think I want to be careful here. If you are making a copy for your own personal use, or
it's a distribution to friends. That's the problem.
Yeah. Yep. Okay. Yeah. Sorry. Go ahead.
I hope that answer also applies to an earlier question about someone submitted about videos of performance, so that they must be covered and sought out for copyright permission. Another question concerns congressional papers. This person has processed the collections of senators and members of Congress, and some of their photographs still have copyright notices on them and still have rights owned by private commercial photographers. I guess this is an observation and not a question. So I'm sorry if I mischaracterized that. This was advice from someone who's been working with congressional papers, and the rights are still owned. Someone wants to know if there's specific language as an institution should include when they commission a work, such as a film for display.
There's all kinds of forms you can find online, and this gets into contract issues. But you'd want to have a clause in the contract that assigns all of the rights for distribution, publication, etc. in the future.
Yeah. Well, I think I've covered the questions asked and tried to respond to them as well as possible. Let me check one more time. We have about two more minutes. Well, this is a very specific question about corpus with the digital rights to Ansel Adams prints in perpetuity. They bought the rights in 1996 for a period of 20 years. How do you tell if they renew them? Are digital rights different from copyright? Ansel Adams prints. It's pretty specific.
Yeah, that's a licensing arrangement, I think, and digital rights are copyright acts. It's the same thing, whether they're digital or in print.
Okay.
Yeah, pen and paper is the same as Microsoft Word in terms of copyright.
I think this will be our final question. Does work for hire apply only when a contract is signed, or does it also apply to regular employees? I'm wondering about the status of research notes, manuscripts, and photos created by faculty at a university.
I think that's a faculty policy question. It's not when a contract is signed, because you can hire a photographer to do a photo shoot for you, but they own, unless that photographer assigns the rights to the institution, they own the photographs and the copyright. If the person is an employee, you're a staff photographer, and you're told to go and take pictures of all the staff, go to all staff functions, well, that's a work for hire because you work for that institution. The institution owns those, as I understand the work for hire clause. Yeah. Most places don't have staff doing it. They hire people outside. And when you hire somebody outside, it's not a work for hire just because they were hired. You have to be a staff person, and that's part of your job to do that.
Yeah, there's an independent contractor clause that they work on now too. An earlier question, I think I tried to help someone answer, correlated to one of your slides, but someone was wondering about family pictures given to a religious community. And I know earlier you talked about due diligence and trying to find relatives, but it may not be possible. Am I paraphrasing that accurately?
Sometimes it's not possible. Yeah.
Your best bet is to get the person who's giving you the collection, because depending on how many heirs they have, it can become impossible to find them all. And all it takes is one who doesn't agree.
Exactly. Yeah.
And then you're stuck. So you want to do that at the time of acquisition, get them to sign. It's scary because they think they're giving away something important. But it's like, you're not going to make a lot of money on this. So people immediately think of money, that there's a fortune to be made here. And it's like, who really wants to buy your picture?
Well, it's not so much money too. In our religious archives, it's this new big threatening question of digitization, because then one becomes a publisher and the expected privacy may be violated. It's an exciting field, really, and worth being very meticulous about to share to secure people's memories and words. Thank you all for coming. I know it was an engaging time spent together, and I hope you join us again. We even have another lunch session next week, and it's going to be on attached to digital work as well. Digital preservation person from Penn State on the NDSA levels of digital preservation. So again, blessings on everyone. Thank you for coming, and I hope we helped.
Okay, take care.
Thank you.